Welcome to the broadcast, and we're with Dean Michael Coyne of the Massachusetts School of Law, the Dean of the Massachusetts School of Law. It's been a while, but he's back, and he's very fresh because classes just ended yesterday, and he's good to go. Right, Dean?
I am, and it's always a pleasure to be back with you. It's a lot of fun.
All right. We have so much to get to today because it's been a while, and legally speaking, it's been a very active time. So let's start locally. The Mass General vaccine mandate. SCOTUS turns down MGH employees' claims of a against a MGH vaccine mandate. Uh, Tell me about that. And I'm curious, as this can be a sort of lesson, how something that gets denied in the lower courts like that can shoot right up to the Supreme Court.
Yeah, that's actually an interesting aspect of it as well. But as many people are aware, there are a bunch of different vaccine cases and controversies existing right now in various courts. And Mass General Hospital had a vaccine mandate such that if you are not vaccinated or receive either the religious or medical exemption, you were going to be terminated. So the employees who opposed that restriction appealed it through the court system, and they filed their action at the trial court level, where cases like that all cases are filed. And then, having lost there, they sought further review. And now, normally, the process is you enter a case in the trial court. It takes some time to wind its way through there, and usually 12, 18 months. And then if you don't like that result, you can take it to the Circuit Court of Appeals, and it could spend a year or two there. And if you don't like that result, then you can ask the Supreme Court to undertake the case. But we're usually talking about then another 9 months to a year for that process. So instead, because of the pressing need for the resolution of these types of issues, what happened is that they did in fact lose, but then sought an expedited review and in essence a stay of that order that either be vaccinated or be terminated from employment. And so what happens is they asked a single justice of the Supreme Court of the United States to issue a stay because they thought their case was sufficiently meritorious that the court should examine its constitutional implications. And Justice Breyer was the single justice, and he denied any request for a stay, not finding that the constitutional implications were as significant as the plaintiffs would have hoped. And so it's a huge setback for those folks because they've got to make a decision about, do you want to continue to be an employee of MGH or do you want to be unvaccinated? And lawyers and people can disagree about this, but the precedent that's been set a long time ago by the Supreme Court, and it's a Massachusetts case, and we've talked about it before, is the Jacobson case. And the Supreme Court of the United States has said is that there can be vaccine mandates. In fact, we know we all have been vaccinated for a variety of things over the years, and it isn't a constitutional intrusion, at least as present Supreme Court precedent says, so that people are losing their jobs. People are going to have to make and have been making hard choices. But the law does not generally support the personal freedom issue that some people are raising in the times of a pandemic like this. And so the Supreme Court, through Justice Breyer, said that there's no stay. And so now those employees have those choices about either pay the bills and continue to work or to have to look for another job.
Seems to me the appeal is based on a pretty lame premise. The way it's worded, the appeal to the Supreme Court said that Mass General Brigham had deprived them of their ability to feed their families. Yeah, no kidding. Anytime anyone gets fired, that happens. Why is that the standard? Why is that the bar? Why would it be? And many of them the sole breadwinners. So what? Should you be treated differently depending on whether you're a sole breadwinner or not? Okay, you can stay because you have a family. You have to go because you don't. That doesn't sound right to me. And another thing was you lose your health insurance. So what? Yeah, there are consequences for your actions. I don't see why that's the grounds that would have any hope at all.
Well, and I agree with you on the general premise is because so I guess if we were to take that to its extreme, is that if you were wealthy and had other resources, then that wouldn't be a problem. So we have another question about the equities within our justice system. You know,
And if that were to hold water, no one could ever be fired for anything.
well, and that is the problem. Exactly. The logic would, to its extreme, would be, well, I really need this job. And you know, an awful lot of people who really need the job made a different choice. They said, well, I may not like it. I may not be as comfortable with the government telling me that this is safe because there's some level of distrust there. But I want to protect my community. And more importantly, I want to protect my immediate family. And I need to pay the bills, at least in part, to do that. So other people have been making choices they would have preferred not to make. All of us, perhaps over the last 2 years, have been making choices that we would have preferred never to have faced. But that's part of the problem here is that you know, freedom isn't necessarily completely free. At times, we are going to need to make choices that we may disagree with, but that ultimately, hopefully, promote more of a common good.
So what's up for them next? Are they just done?
Well, no, they can go back and they'll take the more orderly process, as you suggested here, is how do these cases all of a sudden end up before the Supreme Court? Well, they can go back and continue to wage the battle at the Court of Appeals level, but that's going to take a process of probably about a year, maybe likely even as many as two. And God willing, this problem, at least the immediate problem, will hopefully be over by that point. So the pressing need for the decision is removed because by that point, MGH would have followed through on their problem of if you're not vaccinated, we don't want you in our community. We don't want you potentially carrying that risk to the fellow employees or the patients. And so these decisions will have to be made now, well before that issue will ever be resolved by a court through the formal appeal process.
It's interesting to see how very, very differently people feel about the vaccine. They are so against the vaccine that they'll risk real physical harm at the hands of COVID, and for sure they're going to lose their job. You must hate the vaccine to put up with all that.
I don't always see the reason behind this at all. You know, we see professional athletes opposing it, who put their bodies through great risk on a regular basis for compensation and likely some level of permanent injuries, but don't want to do it. People have mothers and fathers and brothers and people whose immune systems are compromised. I have trouble seeing the reasoning behind it at times as well, and that's the problem from the standpoint of the court cases. Is the court trusts the science? Is it perfect? No, but if the scientists, legitimate scientists, say this is our best chance of success, that's what makes it a legally permissible road to travel as well.
Next up is the Maxwell case. They're charging her with sex trafficking as well as other things. And my first question would be, what is her potential sentence if things go really south for her? And it seems like most of the evidence is witness based. And how will that play out for her? And there must be communications and emails as well. Why don't you fill me in on that one?
Well, she could spend the rest of her life in prison. I mean, human trafficking, the crimes that she has been charged with are absolutely significant and warrant a significant incarceration should she be found guilty. And that's what the interesting thing that people are debating here is that will her status, her wealth, her position, and proximity to people of power, will that again sort of play out so that we see the inequities in our justice system between the wealthy and the more middle class and poor people? And that's the real question ultimately, is that how was this kept so hidden and away from our view for all these years? Because these are not necessarily recent crimes that she's charged with. Many of these happened over decades, and many of them, at least, are connected to very, very powerful and influential people. Some of the names that have already come out include former presidents, presidents plural, and other people who are in significant positions of power. So that's what's kind of interesting from my perspective here. There is a test here in our justice system whether the promises that the Supreme Court has about equal justice under law is real, because she has a strong defense team. As you point out, the evidence is mostly testimonial. It's witness based by the actual victims themselves, but that's going to be the question, whether the crimes were in fact committed. But there's been a relatively aggressive examination of those witnesses, and there will be even more down the road as to what her level of involvement here was and whether the government can prove her guilty beyond a reasonable doubt. It's kind of a fascinating look from my perspective into the sort of this world that most of us never see: private jets, private islands, and wealth beyond what most of us could ever imagine, and power. And that's, to me, why it really does test the equality under our justice system, is that the players involved here are significant. And I didn't realize it till watching the case for some period of time, is that James Comey's daughter is actually the prosecutor of the case. So there's a lot of involvement. And for those that want to look for government conspiracies and wrongdoing, it certainly does seem like there's enough of that that's taken place in part in Florida with Epstein's case, and with the level of participation of some of these folks, that makes us have a legitimate reason to question whether justice will be served here or not.
So many high profile, rich and powerful people stand to lose a lot.
Yep.
Based on testimony that comes forth in this case. Is Maxwell's life kind of in jeopardy? Are they spending extra money to protect her? And are prosecutors, do you think, offering her deals to get at some of those high profile people?
To answer the latter one first, you would expect that, right? I mean, that's generally the nature of if in fact it's operating on the level, that's generally the way the justice system and prosecutors work, is that if you can provide evidence against someone higher up on the food chain, that's worth something to you with respect to the charges you face as well as sentencing. So you would think, if the standard operating procedures are at work here, that is in fact what has been offered to her. That would not be a surprise. In fact, it would be a surprise if they didn't, because it would lend credence to some people's suggestion that the government doesn't want to know. Is her life at stake? We have an awful lot of controversy as to whether Epstein, who never reached trial because he was found dead in his jail cell, whether it was suicide, whether it was intentional, or even if it was simply neglect in allowing him to commit suicide, did that serve some other purposes? I mean, there's so many nefarious levels to this case that, an angle that we haven't discussed is, so now yet we have another case in federal court that we don't get access to when we talk about the First Amendment and the public's right to know. This would be a fascinating trial for people to be able to watch our government and our justice system at work, and to really see what the evidence is and what the involvement of some of these powerful people and wealthy people whose names are familiar to all of us, whether there is really an equality in our justice system. That's a troubling aspect as well, is that we don't get access to this trial as we would, and as we do in the state courts all the time, and as we do and we did for some period of time during COVID. We had a much more public process because some of these hearings were by Zoom, and you could have access to the public ability to sit and watch a trial when the courthouses were closed through technology. Now we don't get that same access. This would be a great trial to really be able to watch closely, because there could be a mountain of different surprises before we're done here.
If allegations are true, you'd have to ask Max. I have to ask Maxwell, what were you thinking? Were you just thinking this is not this is okay, or I won't get caught because these people are rich and powerful, or I'm somehow driven by psychological needs that these activities satisfy in me? I wonder why she would do this. And I suppose you could ask that of any of the participants, but I hope it's not because she's a woman that I'm saying that. I feel like it's her particular alleged role is different than the others.
Agreed. I mean, the psychology at work here it's another level to it that you'd love to have that information. Obviously, as long as the trial's going on, she's really not going to talk about it. At some point, she knows a lot more than we know about this situation and her involvement. Some even argue, and I don't buy it, but some argue that she's yet another victim of Epstein here. But based on some of the evidence already available, she had the opportunity to stop some of this. She participated in, at least by some of the witness accounts, some of the activities. I'm not buying the victim role here for her. I think as a powerful, intelligent person, she had the ability to take steps to prevent some of this. And you wonder whether it's the arrogance of wealth and power that too often we see.
So what's the tack that the defense is taking? Are they just going to try to discredit witnesses?
Discredit witnesses and show her lack of direct involvement, sort of the government's case as a guilt by association case, because it's very difficult to make the argument, I think, at this point, with all we know, that Epstein was a good guy and not a pedophile. So to some extent, what she's got to do is create that case of reasonable doubt. Is there enough evidence here to actually convince you beyond all reasonable doubt of her level of participation such that it violated the criminal statutes in question? And argue in part it's guilt by association. She had a relationship with Epstein, but what he did is separate from her involvement. It seems like, based on the evidence so far, that she's going to have a tough job disassociating herself from Epstein, but she may have more success creating that case of reasonable doubt.
Next up's the Alec Baldwin case, another super interesting case. So in case folks that you don't know what's going on there, movies being made, and a firearm is used on the set, and everybody, well, one would expect it would be empty. It turns out it wasn't. And is it a director of photography, I believe, was killed. Another person was injured, and everybody's passing the buck. Everybody's lawyered up. Why don't you just give us some background, some more detailed background on this one?
Well, it's another mess. I mean, it really is an interesting time for litigation, and what will ultimately at some point be a trial of that matter as well. Because if it's not necessarily a criminal case charging Alec Baldwin, there will be likely criminal charges, as well as a significant civil case for the death of the individual on the movie set. And what happened is they're filming a movie, and it's a Western, so they're using guns. And at some point, Alec Baldwin has a gun that shouldn't have had live rounds in it, but it appears it did. And the gun went off, and the director of photography died. And someone else was shot and seriously injured as well. And so now we're all questioning, well, A, how something like this happened, but why weren't the folks in charge of the movie really taking many more steps to make sure people are safe? And as it turns out, I think there's a general question about, well, why are we using real guns and real live rounds on any movie set? And why does it have, these days, especially with technology, there's a way to make it look just as realistic if you need to have that level of realism, at a much more safer way. And so it's just a mess, because someone's seriously injured, someone's dead. Alec Baldwin's holding the gun. He says he didn't pull the trigger, but as someone points out, guns don't shoot themselves. And so somehow people are responsible for there being live rounds within a weapon, which shouldn't happen. And how does the gun go off, based on the information we have, without someone being involved?
As I understand it, he cocked the weapon. It had a hammer. It was an old style Western gun. And when he released the hammer, somehow, maybe he released it too quickly with his thumb, and it actuated the round. I don't know. But either way, you may not have pulled the trigger, but you actuated the round. You made it happen. I guess I just have to say here, this might be a good opportunity for the court to send a message that anytime you receive a weapon from someone and you pass it along without properly checking it, going through the routine safety checks that every responsible gun owner has to do when they accept a firearm from another person or pass it on to the next person. If you don't do that, you should be on the hook for the results. And I don't know what they would be. Maybe criminal negligence resulting in death in this case. Everybody that touched that weapon and passed it on should be on the hook in some way to send a message to everybody in the country. And I know you just can't go making stuff up like that in the court, but still, I think you know what I'm saying.
No, your basic proposition that, the idea about criminal negligence, or negligence to such a point that it's grossly reckless, that finds its place in the law. The fact is what you suggested is no one should be touching a weapon who doesn't understand how it actually works, to the extent of how even a slight misuse could have such tragic consequences. So it's not just, as you point out, the person who's handing you the weapon that could cause that type of problem, but you shouldn't be accepting it. And we certainly shouldn't be having actors who, in many cases, are going to have no experience with firearms or gun safety, handling weapons that are capable of deadly force. And so that, if you think about it that way, there's a whole bunch of people that potentially have liability here, criminal liability, for the manner in which this ultimately went down, because there's so many failures here, including the actor himself, who handles the gun in what, at the minimum, sounds like a negligent fashion, even if his claims of not pulling the trigger, or whatever that means to him with respect to releasing the hammer or whatever, the bottom line is there's failures at multiple levels that likely warrant criminal charges, and certainly will meet the civil standard of negligence, so that we will see judgments of millions and millions of dollars, or settlements more likely. But money's obviously not going to bring the children back their mother under the circumstances either.
If I were an actor and someone handed me a gun, an actual gun, and I was expected to point it at somebody and shoot it, there's no way I would not do the proper checks on the weapon. I just can't imagine anyone would do that.
But Bradley, the proper checks. Okay, you are experienced with firearms. I'm not. So if I was the actor, I'm not even sure exactly how I would go about checking it to make sure it's completely safe. Because, in my sort of warped view, I'm not sure a weapon with ammunition is ever going to be completely safe. And I hope, but I'm almost guarantee, there's no type of real training that takes place on set to show actors how to properly handle weapons. And that's a failure in and of itself. Some movies and TV shows at this point have banned, because of this, banned the use of real weapons, period, because of the potential for such tragic consequences. And especially with technology, there almost is no reason to do that any longer. It may be a little more expensive to do it with a green screen and through technology after the fact, but it certainly is 10 times safer, if not a magnitude even better than 10.
So what's Baldwin's maximum exposure legally? What's the
Well,
worst that can happen to him?
Well, you're looking at potential huge civil liability in the terms of millions and millions of dollars, and you could still see, even though at least based on present reports, it looks like they are not pursuing criminal charges against him, that you could still see some type of relatively low level on the grounds of your criminal negligence count, where he would be charged and likely with an agreement that he would not, if he resolved the case, he would not go to prison or do any or spend any time in jail, but that he had served some type of probationary period or something like that. And I could see a deal like that being arranged based on the evidence we have right now, because it seems like someone else is far more culpable for having live rounds on the set, which never should have happened, and then having live rounds within the gun itself. But again, a lot of this is based on what present knowledge of the facts, and it's sort of come out in dribs and drabs. And maybe obviously someone has a lot more information as to how this all took place that led to such a tragic result.
I wonder out loud if Baldwin has liability insurance for something like this.
I wouldn't be surprised. First of all, he's one of the producers on the set, so there would be coverage for the company. And I would not be surprised if he had umbrella coverage for liability for various acts. It's not uncommon that people, anyone might carry an umbrella coverage in addition to their homeowner's insurance and other types of basic insurance. Certainly when you have significant amounts of assets, as Baldwin does, that would be a relatively common practice. Plus, it's also a relatively common practice. He's been pretty combative over the years. He gets into dust ups, so that he may very well carry some type of insurance to make sure that, as a target as he is, that they would both defend the actions and then pay potential judgments for people that would feel he's an easy target for nuisance suits because of his status.
Now it's time to take a look at the Rittenhouse case back in August of 2020, Kenosha, Wisconsin. Black Lives Matter protest. Rittenhouse shot 3 people, was it?
Killed 2 and injured the 3rd, but he did shoot 3, right?
Yep. Claims he shot him in self-defense, but the prosecution said, hey, the situation, any situation you may have been in that required self-defense was incited by you. And so that's interesting there. And there was a lot to unpack in this case. He said that he was asked to help defend a gas station. Who knows what was true? Anyway, I'll let you take over from here.
Well, we had a fascinating series of cases there between Rittenhouse and Arbery down in Georgia. And the first verdict that came in is Kyle Rittenhouse was charged for the murder of 2 individuals and the shooting of a 3rd in Wisconsin, while there was a protest going on. And in fairness to the government's position, a very, very violent protest. And so what happened is a number of individuals came to assist the police with trying to keep order, we'll say. And what happened is we had people, including Mr. Rittenhouse, and when I say Mr., he's a 17-year-old with a high-powered rifle running around the streets of Wisconsin, trying to keep order, if you want to call it that. But it was pretty disorganized chaos with a high level of danger present. And so this 17-year-old ultimately said, in defending himself, it was necessary to use the deadly force. And if you saw pictures of it during the trial, It was a riotous situation. There were dumpsters on fire, and there were people running chaotically around, and there was real danger present, no doubt. But many believed, and if you worry about it, hopefully you should, is how does a 17-year-old how is a 17-year-old authorized to run around with such a deadly weapon, ultimately kill two people, and be found not guilty of any charges whatsoever by claiming self-defense? And that was his defense here, is that self-defense allowed him to use the deadly force because he was in fear of his life. And in Massachusetts here, we have a castle doctrine. If someone breaks into your home and you're afraid that they are going to kill you or a family member, you have the right to use deadly force. The fact is, other states have similar types of protections. But the point is, oftentimes with self-defense, when the use of deadly force, you don't have the ability to use that defense if, in fact, you are the instigator. And that's
Right.
I think in this case, when you look at it, how is he not an instigator when he goes into this melee with running around with the rifle and ultimately faces people who are going to do him harm, at least in part. One of them testifies, because he's running around with a rifle and I'm in fear of my safety. So it's really a mess of a situation, and horrible. But ultimately, then the jury comes back and agrees with his self-defense argument and finds him not guilty of any charges whatsoever. And that's, I guess, where I struggle with it. At the minimum, his actions seem grossly reckless. He didn't need to be there. This was not his hometown. He certainly didn't need to go with a weapon, which would raise the ire of many people, and others would obviously be concerned and run away. But those that didn't ultimately then faced the deadly force.
So, how did he manage to win the case? Is it because the facts just weren't clear enough, and in order to find someone guilty of murder, they have to be pretty clear? It was just too muddy, too messy.
I've thought a lot about it, because at least one thing, my immediate thought that came to mind is that if he was a 17-year-old black kid running around with that weapon and shoots two people, he almost would have absolutely been found guilty and sentenced to jail. So it worries me about the inequities in our justice system again. And so if that premise is right, then that should be worrisome. And it is worrisome, because I do think there's much truth in what I just said. But if we want to take a step back and look at it, is there some legitimate, from an evidentiary basis and law basis, for his argument on self-defense, and a reasonable decision that the jury could come to beyond the race of the accused? And to me, the more I thought about it, and what's interesting, another interesting aspect, is he used O.J. Simpson's jury consultant to pick the jury. So there was a lot of money put into this case by others who wanted the result they ultimately got. But when picking the jury, if you think about it, for those of us that saw some of the images with the burnings and the chaotic, dangerous situation that the police were having real troubles controlling, if that was your community and you were then ultimately later chosen as a juror, maybe you wouldn't be so hostile to someone coming in from outside trying to help save your community from ruin. Because we've seen some of these riotous situations where communities are torched and destroyed and take years to recover from.
Right.
And so I think the more I think about it, he had a friendly jury to begin with. He had the good fortune and friends that helped select an even more sympathetic jury for him. And I could see where such a jury then could examine it in the light most favorable to the defendant and say, no, he was in self-defense. One of the individuals grabbed a gun. grabbed his gun. Another said, "I'm going to kill you." That may well be enough beyond the race of the parties
Right.
involved to be able to say, no, that the government hasn't shown beyond a reasonable doubt that he violated the criminal statutes. And
Right.
so there may be some hope within that, in viewed in that way,
Hmm.
that this is a decision other than where race plays a factor.
Right.
And
Now that you say
right,
that, I guess you're right. You can't really judge a situation like that from outside. I mean, if everyone in your community is in fear for their life, that's got to change your viewpoint.
I think so. I mean, one of the places that was involved was a gas station. Obviously, if the fire goes differently, that could be tragic. I think I do worry that as people started to think is, well, I don't want this happening to my community, and I'm glad someone helped, and maybe that makes sense. And what helps make sense is the Georgia case, the Arbery case, where the jury did look at the case. Same argument about self-defense. The young man was running through the neighborhood. He was jogging. The prosecution claimed, and the defendants said that no, he wasn't jogging. He was out hustling around, going to rob the neighborhood. He had been in other houses, and so they stopped the Ahmaud Arbery. Ultimately, then the three white men shot him in Georgia and killed him. And they're charged with murder. And they were arguing the same thing, is self-defense. And that would have been really worrisome if back to back we had two decisions where self-defense, in essence, is saying vigilantism is okay, and that people who aren't trained law enforcement officers have the right to use deadly force on with not a significant amount of evidence to support it. We don't even allow police officers to use deadly force to shoot fleeing felons anymore. Tennessee versus Garner, long time ago, said, listen, it shouldn't become a capital offense if you can avoid it. But what we had in Georgia was three men cornering Ahmaud Arbery and then ultimately killing him. And what we had in Wisconsin, was another individual taking the law into his own hands. And so if both of those verdicts came in not guilty on the basis of self-defense, that would have been very worrisome as to both the equality under our justice system, as well as whether juries are now condoning the private parties to use such deadly force where police officers can't even use such deadly force under those circumstances. And so it sort of righted the ship a little bit. And the difference really being between the two cases is Rittenhouse had some evidence to support that he felt his life was in danger as a result of his confrontations with these individuals. And in the Georgia case, they really couldn't show evidence, or they had some evidence, at least their beliefs, but they didn't have real evidence to support their argument that they felt in fear of their safety when the three men with their rifles were confronting the young jogger and felt the need to then use deadly force. So the self-defense in the second case was not available to them, or at least the jury didn't buy it. And it may well have been based on what we said before as well. If you instigate the confrontation, you shouldn't be allowed to take advantage of self-defense under the law. And the jury may have found that as well, is that they could have let him run away, or let it continue to run, and we wouldn't be here at all.
Right. Two more quick cases. Phil Cate up in New Hampshire comes to us on Facebook. He says he mentions the Michigan case, school shooter, and I'm curious about the legal culpability of the parents. That's among the most interesting thing there.
Yeah, it's a great case. Normally we don't hold parents accountable for the criminal acts of their children. For those of us who have had children, that's generally a good thing. But here, we're not holding them accountable for the acts of their children. We're holding them accountable for their own criminal negligence, what I would call gross negligence under the circumstances. And criminal liability attaches for gross negligence, even to the point where that can constitute murder. Murder charges themselves if you're grossly reckless when you do something. And here, if you look at the facts of what the parents' involvement in this school shooting, where 4 young people met their death, they purchased the weapon just days before with the child present, with the 15-year-old present, and it was a gift for him that they had purchased for him. They were called to the school the day of the shooting and urged to get the child counseling right away, because the school system had seen him looking at ammunition on his cell phone and had some really sick, dark thoughts about, I can't get these thoughts out of my head about killings and the like.
And he was drawing pictures of those thoughts.
Exactly. And then the parents left him there. And so then the school system allowed him to remain present, and just, I'm going to call it moments later, after the parents left and after they released him back to his classroom, the shooting began. So the parents didn't just set this in motion by having the child. They likely created this little monster and fostered these problems. Their liability stands on their own for setting this dangerous scenario in motion and knowing the danger. They never disclosed to the school system when they were there that day that they had recently purchased a handgun. It was in the house. They didn't look in his backpack that day, where the parents clearly would have, and so could the school system have looked in the backpack. So there's failure on multiple levels. But this is the rare case where it's the parents should, in fact, be charged as a result of their child's criminal activity. And it's based, at least in significant part, on the parents' criminal acts here as well, in making such easy access to such deadly force with such tragic consequences.
Does negligence ever rise to the level of complicity, either aiding or abetting, or up to conspiracy, complicit, being complicit?
Yeah, it can. In what we usually, when negligence rises to the level of what I'm going to call it gross recklessness, when you do something so bad negligently, you're so careless, like leaving the weapon in the house unattended where he knows it is. That's so careless. And careless is just another word. Negligence and careless really mean the same thing. Negligence is the legal principle we attach to it, and there are certain elements. But if you really want to think of what negligence is, when lawyers and the law talks about it, it means carelessness. So to the extent you are really careless, then that ultimately can constitute negligence, whether it's in a car accident, whether it's in a product, whether it's in a shooting. And here, can't we look at this case and say these parents were incredibly careless with the manner in which they purchased the weapon with the child present, stored the weapon at the house, even assuming they didn't give it directly to him. You know, I have 3 kids. One of them always, he's been looking at for Christmas. He's 30-something years old, and he's still looking for Christmas presents around the house already. We know that when children want to find something, oftentimes they are industrious enough to do that. And here, this is obviously something this kid wanted badly, had a desire to use it so improperly, and not to store it properly, to make sure he knew that there was one within the house because he was there. This is just bad on so many levels that, yes, I think the parents were careless to the point of grossly reckless, and that will create criminal liability.
Okay. And finally, will Steve Bannon go to jail? And if not, what's the point of even having rules like he was laws that he was used to be charged with? They don't seem to have any teeth. rich, famous people seem to know nothing's going to happen to them. There you
Wait,
go.
wait a minute. Let me write that down. The rich and powerful have a different justice system than you and I and the rest of us.
It's a joke. He knows nothing's going to happen to him, so he can just blow them off.
Well, hopefully, sooner or later, something will happen to him, because you cannot continue to be in contempt of Congress or in contempt of court orders and not ultimately pay the price for that.
But you can, it seems.
Well, not forever. That's the point. At some point, he will test the judge or the Congress's patience to the point where they will have no choice but either to jail him until he complies with the order, or, as you point out, walk away and say, forget it. We just can't do anything about it. And I don't see the latter happening. You know, people go to jail for contempt of court orders all the time. If you don't pay your child support for long enough, and you can pay it, but you choose not to, you're going to go to jail in the probate and family court here. And
if I'd done what Bannon did, they'd have thrown me in jail and thrown away the key.
Yes, if you or I did it, we would not have stood a snowball's chance in hell of continuing to walk around with such bravado. But it is different for the rich and the powerful and the connected. And I think, though, to prove that our justice system can sometimes be a little more equal, I think Steve Bannon will ultimately face the price for such hubris, and ultimately either comply or he'll be held in jail until he does.
But won't he go to, a Martha Stewart jail?
Yeah. He won't be going to beautiful Walpole or some other
Cedar Junction
likely facility. Cedar Junction now, likely facility where he will face grave consequences. But with that said, Epstein was in New York with all the other bad guys.
Which was weird, right? That was weird.
That was different. And so maybe Steve Bannon won't go to a country club type of place. And while he's held, if he's held in contempt until he purges himself, they may well keep him more local so that he can find that he should comply with the order. And, people can have a lot of bravado until their freedom is completely taken away from them. We can say it's a country club prison, but it's still not a place you want to go, and you don't want to have your freedom restricted. And you can think you're the toughest person in the world, but when you're incarcerated for any period of time, anywhere, you're not going to like it. I've been to a few places because of my work, and even knowing you're getting out at a relatively reasonable time there, it still is kind of a scary place to be, knowing that there's danger. And particularly if you were to spend nights there as well, you would not want to stay there long in any place that restricts your freedom to that extent.
It just irritates me when people get away with stuff that I can't get away with. So, and this has nothing to do with politics at all, because of that, what I just said. I don't want people getting away with stuff I can't. I want to picture Steve Bannon in the jail with a tin cup banging on the bars for the warden. I want to see him. I want a photo of that. All right. Well, thank you very much, Michael Coyne, and congratulations on another year as dean, another semester as dean of the Massachusetts School of Law. Great place. I'm glad we got you on the day after the final day of classes. Otherwise, we never would have had you for this big, long period of time.
Me too. I appreciate it. Happy holidays, everyone. Have a great one.
Hopefully we'll see Michael again soon. Bye now. And we'll be clear in 3 and 2 and